here today for the nomination of individual Munevar to the position of Justice of the House. I'll read the governor's letter. Dear counselors, I'm pleased to nominate Alex Munevar to the position of Justice of the Housing Court. I submit this nomination to the advice of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. So with that, I will, I'm going to skip the introduction of our counselors because I will introduce them as I call them in order. But let us call your first witness, and I believe that is Katherine Downing.
Good morning.
Good morning.
Everyone can hear me, I hope?
Yes, ma'am.
I want to thank you all for the opportunity to come and speak to you about something that I'm actually very passionate about, which is housing. I've been told that I've got to be short and sweet. You know, that's hard for lawyers, but I'm going to try to do that. I want to tell you a little bit about myself so you understand why I'm so passionate about what I'm going to be talking about. I have been an attorney for 37 years. 35 of that I have spent in the affordable housing industry, representing mostly landlords, almost exclusively. We represent between 75 to 100 sites throughout the Commonwealth of Massachusetts. I also chair for the Massachusetts Continuing Legal Education, the Housing Court Judicial Forum, the mock trial of an eviction, and reasonable accommodations demystified. I bring these up not to brag about myself, but to get you to understand that I do have a really good perspective on what I perceive to be best qualities for a judge in the housing court, and why I'm here on behalf of Alex Munevar, because I've had the opportunity to get to know him over 9 years, both professionally and also personally as well. I've had a chance to be able to observe his demeanor in the courtroom. He also has been, I've invited him to be part of the panels for the MCLE programs, first starting with the reasonable accommodations demystified, and then most recently he has been one of the panels on the mock trial in an eviction case. And what that means is we actually present to the people that are there the best practices in terms of being in front of a court, presenting on behalf of a plaintiff, which would have been in the other side. But Mr. Munevar has he stepped in 1 year at the last minute to cover for the attorney that was going to be doing the defendant. And he did such an outstanding job that I made sure that I invited him back to the panel the next year. And I have been very impressed with him. I also will tell you, I have watched him argue in court. So I have a pretty good perspective about his personality, but also his qualifications. I've also mediated hundreds of cases with him. And I want to bring all of that so that you understand that this isn't just somebody checking the box, because I'm in a very unusual position. I'm here on behalf of somebody who has been on the other side of most of my cases, and unusually a landlord lawyer is up here talking on behalf of somebody from legal services. Let me also give you a couple of examples. As I've said, I've observed him in court making arguments. I was impressed from the very first time I saw him, I think about 9 years ago. He was arguing a case on behalf of a tenant that had lost a subsidy. He was incredibly well prepared as to the facts and to the law, very responsive to the court. He was polite, he was focused, and he made a really good argument. And too often, sometimes what happens is lawyers are up there arguing, they're arguing because their ego is large enough to fill a closet. That's not Alex. He was up there because he knew he had to convince the court of the rightness of his client's position. I believe in that case he actually won, but I was really impressed with his argument. And because of that, the next time I saw him in court, he came up and he was negotiating with me on behalf of one of his tenants who happened to be one of my client's tenants. And I was again impressed by the fact that one of the things that he is really good at is he understands the pressures of both parties. And that's unusual to have somebody from a defendant's perspective wanting to understand what the landlord's perspective is in terms of potential liability and understanding. And because of that, he could come and present the case to me for resolution in a way that made sense for for both parties, including my client. And that can be very unusual because, again, as I said, I work in affordable housing, and a lot of times people think that it's all about how do we get rid of somebody. He was able to present and has been able to present resolutions that actually get to people to what they need. May not be 100% of what everybody wanted, but it gets people in a chance to be able to change their behavior so that the landlord can be assured that, in fact, this is going to happen. The other thing that I like about working with Alex is he follows up. He doesn't just sign an agreement and walk away. I am very comfortable with calling him and saying, you know what, your client has a problem, and he tries to address that before it comes, and that's before it becomes even worse. And that's important to me in a judge, because if you can understand the pressures that are on both sides of the versus sign, you can understand just exactly what's motivating people and be able to maybe encourage them to resolve the issues. I'm going to tell you that he is very quick-witted, but he's not at all caustic. He's not nasty. He will gently suggest to you that perhaps you may not be as right in your opinions, but he's not mean about it. He's very respectful and he's very polite, but he also listens, and he listens with a good, compassionate ear. So even if he may not agree with you, he always is willing to listen to your perspective. As I said, it's a rare ability that you find in either the landlord or the tenant bar, that they understand the pressures that the other clients are under. Because of that, he's able to give his clients a result that actually gets them to be able to succeed where they are. With regard to observing him at trial, as I've indicated, he stepped in on the MCLE, and I brought him back. What I also did is I also volunteer teach for a property managers association, and we set up a mock trial with a judge to present in front of property manager and staff. And I happened to choose to be the plaintiff's attorney in that particular case. And I will tell you, it was not only a lively, but also a very instructive case and a presentation for the people that attended. And we got very high marks, mainly because of the way that Alex was able to present his case, which was dealing with a person, obviously a fictional person, who had real needs in terms of an accommodation, in terms of a service animal. As you probably may or may not be aware, since I first started, housing law has become very complex in the sense that it's now become intertwined with issues of family law and probate law, immigration, not to mention the overlay of federal and state regulation. And one of the things that I find unique about Alex is he's had a background before he joined the housing unit in most of these things. He has a background in working with probate. He has a background dealing with immigration, and he has a very firm grasp of the different types of subsidy. And because of that, he's able to spot an issue that might, in fact, have to be addressed before the parties can either resolve the case or the case has to go to trial. Again, I think that this background has made him a very well-rounded attorney. As a matter of fact, I am comfortable enough with him that in a case that I had involving one of my client's tenants who had some mental challenges, asking Alex to actually personally jump into the case, to sit down with the resident to try to explain to him how to resolve. And that's not usual for me. Usually we try to, say, okay, well, legal services is going to come up and they're going to, berate us about how horrible we are. He does not do that. He understands, he's respectful. So if you're asking me why I'm supporting him, I'm going to give you the characteristics that I see in him. He's patient, he's balanced, he's thoughtful, he's thorough, he's well-versed in the law, and he's also practical. So that's why I'm very proud to be here on behalf of Alex's and to support him. And I think he's going to be one of the best housing court judges we'll ever have. And that's my point of view. And if anybody wants to ask me a question, I hope that was short and sweet enough for everybody.
Thank you very much.
Thank you very much.
Do any of the councils have questions?
Councilor Duff?
Councilor Duff?
Yes.
Yes. I do.
Please ask.
Am I going?
Am I going?
Okay.
Council Hurley, is that you?
Yeah. Yes.
Yes, please ask, and then Council Jubenville.
All right. Attorney Downing, you've certainly taken into consideration all aspects of what you believe would make Mr. Mitchell Munevar a good judge, but he's that in person.
That's correct.
And
That's
do you
correct.
believe that he can, instead of being an advocate for tenants, that he can basically not have any leanings or prejudice in favor of tenants in making rulings?
I absolutely believe that he would be impartial in that kind of situation. I don't think, if you ask me, does he lean towards tenants? I think he leans towards trying to find a practical resolution of the situation. That's what I mean when I say he's very good at being able to understand both sides' perspective. I don't have any fear that he's going to get on the stand on the bench and be, what I would view as being an ideologue that I'm going to beat up every landlord, because again, he understands what they're doing and understands what their motivations are. So I've never, even ones when we're arguing the case with each other, I never get the impression that he thinks every tenant in the world is right and every landlord is wrong. I think he judges based on what the facts are in front of him, and I think that's all you can hope for a judge. And I just, it's interesting because people always ask me, well, he's on the other side. But in this kind of situation, particularly when you deal with a judge, part of what you're looking at is whether they can see beyond their own personal beliefs, their own personal biases. And I think that's what you have with him, is he's able to look clearly at the facts, give both sides the credibility that they deserve in his courtroom, and then come to the conclusion. I don't get from him ever that his bias is always tenants and never landlords. I hope that answers your question.
If there is no solution.
Yep.
And a decision has to be made, evict the tenant or keep the landlord on the hook and continue the case for 30 days and continue the case for 30 days. What is he going to do?
He's not going to continue it for 30 days. I can tell you that because that's a strategy that legal services uses. I have never had that with him. If the only time we agree to continue, it's because there is something that needs to be resolved, and I agree it needs to be resolved. For example, there is a subsidy that has not been finished processing, or there's a piece of information. And I will say this, if he asks for continuance, he will come back with the answer before the end of that continuance. So and I've been in front, believe me, I've been in front of plenty of judges that will just kick the can down the road. That's not my experience with him. He's looking to resolve the case because, again, that's keeping all the parties in an unfair limbo. And I mean both the landlord and the tenant. The parties need to have a resolution so that they can learn to move on. And I think that's what his goal is of the entire time that I've worked with him.
All right, thank you.
You're welcome.
Councilor Jubinville?
Thank you. Hello?
Councilor Jubinville?
Yeah, I have a question for the witness.
Yeah, please ask.
Okay. How many cases have you had with the nominee?
Okay, over 9 years. I'm going to estimate 150 to 200.
Wow.
And when you say that he's not going to continue the case for 30 days, what about the situation where the people that are being that are going to be evicted don't have any place to go, Yeah. Think it's sufficient to give them 30 days to find a new place if they're in arrears of payment on rent, getting thrown out of the apartment?
The experience that I've had with him is that if he is trying to find a middle ground, he's going to try to find a middle ground that will make sure that there's a benefit to both parties. So again, even when he asks me to give his client time, he's always saying, look, here are the conditions. They need to pay their rent. They need to behave themselves. So again, that's what I mean when he understands the perspective of the landlord, because you're right. There is a balance there. Both sides, if somebody needs more time, they need more time. And from the landlord's perspective, they want to make sure that they don't get further harmed. Because the underlying all of this is the benefit to the landlord in terms of giving a little bit more time for somebody to leave is that they're not going to pay the $2,000 to $3,000 it takes to have to physically move somebody out. And if they can be put in the same position, in other words, they don't lose any more rent, there's no other behavioral issues until that person moves out. So that's what I would expect him to be doing as a judge. If he does grant more time, he would wrap it around with conditions that would make sure that the landlord is also protected as well, because that's what he does when he we have a discussion as to whether or not to grant more time or not. And also too, even when we're in front of the judge arguing, he will suggest that, his client would be willing to pay rent in the meantime, and suggest that his client would be willing to comply with the terms of the tenancy as well.
Okay, what do you think is the most important quality to have as a judge?
I'm sorry, I missed the last part of that.
What do you think is the most important quality you have to be a good judge?
I think you got to be patient and you've got to be practical. That's the 2 P's as far as I'm concerned. Actually, there's 3: patient, practical, and prepared. And if, again, under the pressures that you have in the housing court, cases come like this, but you got to be patient to both sides. You've got to think of a resolution that would, in fact, not make the situation worse. And you've got to understand what the underlying facts and the law tells you to do. And I think Alex has that in spades.
Thank you.
Thank you.
Any other councils?
I have no questions.
Okay, thank you. Council Kennedy?
Marilyn, that's sorry, Marilyn had her hand up. That's all.
Thank you, Councilor
Debate. Are you calling on me?
Yes, I am.
Yes, I am. Before I question Councilor Duff in respect to my colleagues, I respectfully ask you to introduce the councilors who are here for people to know.
Councilor, I'm running
the
that. Please ask.
I respectfully ask.
Please ask your question.
What is your answer?
Please ask your
question.
Part of the hearing.
Correct. First of all, it was difficult to hear you witness. And first of all, I want to thank you because this was very quick, and you only had, just a couple of days to accept. So I did have trouble hearing you. So if I am redundant, please let me know. First of all, tell me again how you know the nominee, what interaction you've had, how many years?
I've known 9 years. I met him. I'm sorry. I'll try to get as close to my microphone as I can. Does this help a little bit better if I move over? Can you hear me a little bit better? I've known him for 9 years. I met him through the housing court. I first saw him argue a case. I was impressed with the quality of his argument and how precise and focused he was, and how he was very good with interacting with the judge. After that, I had a series of cases with him where I'd bring an eviction action and he would be representing the tenant. And again, as I said, what I was struck with is his understanding of both parties' pressures, particularly the landlord's pressures, why we were there, what we were looking to achieve. And he took that into account when he was proposing a solution. And because of that, we were able to reach a resolution that was, first of all, easier to reach, and second of all, was much more in line with what both parties needed as opposed to what they want, because sometimes parties have unrealistic expectations when they come to court. As I answered to another one of the counselors, I've worked on about 150, 200 cases with him over the 9 years in terms of working with the tenants that he represents. And I also have been impressed enough with him to invite him to be part of the panels that when we teach other lawyers about this area of law, an area of law that I'm very passionate about, including the fact that he has been on at least one occasion my opponent in a mock trial that we were using to teach property managers about what it's like to try a case. Does that answer your question, Mr. Vaney?
Yeah, thank you. What comes to mind as that made the most impression on you of a case that the nominee has had?
We had a case where one of my clients services formerly homeless people who have mental issues. And he and I worked very hard together to try and work out a resolution so that that person could get the supportive services they needed in order to be able to comply with the agreement. Because we put an agreement in effect that the tenant was to comply with certain issues, certain behavioral. And I'm very happy to report that throughout the course of that agreement, Alex didn't just put that file into his filing cabinet and forget about it. He would check in with me regularly as to whether or not, his client was complying. And that's pretty unusual, because I think sometimes what happens, we lawyers think, oh, well, that's done, dusted, put it away, I won't think about it again. But he was interested in two things. One, that his client succeed, and number two, that my client saw that his client could succeed. And that to me is, if you're truly in the landlord-tenant area, and if you're in the affordable housing area, sometimes that tenants may just need an opportunity to be able to change their behavior to be able to succeed. He's also, and I will say this, there have been occasions where it's clear to him and to me and to my client that his client will not succeed. And what he tries to do in that kind of situation is negotiate a way that his client will have a graceful way to exit, as opposed to being dragged out on the street and stuffed into a moving van. And that I find admirable. I know that's an odd situation to say for a landlord, but most landlords in the affordable housing, it's actually losing if you have somebody who is physically evicted. Now, that does not include, obviously, people that are involved in guns and drugs and the worst part of our society. But again, if what we're trying to do is house vulnerable people, and that's what my clients do, there's got to be an understanding to both sides that you need somebody who's going to be practical about the resolution. Is that a response?
With your experience, how important is it for a judge to have, for a nominee to be a judge, to have trial experience?
The realistic thing in the housing court is 90% of the cases that are there are actually resolved through either mediation or by negotiation between the parties. So I will tell you, in 37 years, I don't spend the majority of my life trying cases. I do try cases. What I think is more important in terms of trial experience is to know exactly, what the rules let you do, to be able to present your case in a really focused way so you're not wasting the court. I will say this, because I would not have been willing to have either the property managers or the other lawyers learn from somebody who did not know how to try a case. And that's by far and away my biggest saying, that Alex has the experience that you need in order to be able to understand how a trial is conducted and does it well. In the most recent seminar that we had, he was representing the tenant, and there was a very experienced attorney representing the landlord. And I watched as he, had a point that he wanted to make, and he did a really good job of doing it. And the other side just could not figure out how to make, get that point undone. And that's somebody who is very good at presenting the case. And having said, if it's good to have courtroom experience, not just trials, but also motions as well. I don't think it is the absolute end point if you have people who are able to understand what it's like to be in a courtroom. And I think Alex does have that experience.
Well, the reason I asked you in my investigation that I found, I was told that there's a high percentage of cases in our housing courts in Massachusetts that go to trial. So that's why I was into that question. Thank you very much.
The majority of cases in the housing court that try tend to be ones where you have unrepresented parties.
Muffled. I'm not having trouble hearing you.
Oh, I'm sorry. The majority of cases tried in the housing court tend to be cases that fall into one of two categories. One is both parties are self-represented, or you have people that you do have the complex cases that take several days. I agree with that, and there are ones. But again, the point of what the housing court really does push to do is try to get resolutions that parties can live with, knowing that there are some times where you have parties that cannot or will not resolve the case. And those, I think, are the cases that you're referring to, which are all the trials that happen.
Thank you.
Thank you. Thank you.
Any other counselors? Okay, with that said, I'd like to say I've received a plethora of letters and a few phone calls, but a plethora of letters in support, which I will submit into the official record. At this time, I would like our nominee to make his statement. If there's anyone there that he wants to introduce, he may. If not, just make your statement and we shall commence.
Thank you, Councilor Duffy.
You're welcome.
You're welcome.
So, good morning. I'd like to first thank this council for allowing me the opportunity today to discuss my qualification for the position of the Associate Justice of the Housing Court and to hopefully answer your questions. I'd also like to thank the Governor, Lieutenant Governor for their confidence and their nomination, as well as the Chief Legal Counsel, Bob Ross, JNC Executive Director, Laura Green, and Deputy Director, Munevar. Before moving into questions, I'd like to take a brief opportunity to share a little bit about my background and myself. My personal story starts with both humble as well as new beginnings. I am a first generation born from immigrants who arrived here from Colombia, South America. My parents arrived here well over 30 years ago, seeking, like so many others, more opportunity and a chance to raise a family. I was born and raised in central Massachusetts, Worcester, and attended public schools and graduated from college in Worcester. My parents throughout their whole lives were laborers. My father worked assembling rifles for our servicemen in Vietnam. He worked assembling hand tools at a factory, and at one point he worked for the tabletop pie company, while my mother worked in an old-style shoe factory, Brown Shoe. Both my parents ended their working years after a long period of time with the Digital Corporation. My parents were hard workers, and they did their best to provide me, my brother, and my sister what we needed. They often lamented, though, how they were never given the opportunity to graduate from high school and even on to college. And so, with that sense of loss, it motivated my parents to instill in us both a drive towards education and ambition. Though my parents supported my efforts, their ability, however, to participate and guide me through what for them and for me were life experiences was limited. And so I had to develop a strong sense of both perseverance and self-reliance. I was fortunate, though, to have so many people along my journey, too many to thank, that intervened to lift me up, even when I felt uncertain and shaky. It is my parents and those mentors who have unconditionally inspired me to pay it forward and to serve the greater good. After graduating from the College of the Holy Cross, I began my career in public service as a child protective service worker for then the Department of Social Services. My experience there only fueled my desire to have more meaningful impact on the many needy families that I met, and so I decided to pursue a career in law. Following law school, I was again fortunate to have another mentor, Judge Angela Ordonez of the Probate and Family Court, who offered me an opportunity to serve as a volunteer clerk and who directed my career towards public interest at Greater Boston Legal Services. For nearly 20 years, I have served countless families and individuals, whether they were survivors of domestic violence, or struggling with loss of income and denial of unemployment, or trying to navigate the complex process of qualifying for Mass Health. I've been privileged to have served so many, especially during my last 11 years as a housing advocate, helping families avoid homelessness, while also being considerate of the challenges housing providers face. I see the opportunity to serve as a justice of the housing court as not only a chance to continue serving in the public interest, but to also assist the court in its endeavor to ensure access to all needed services and to ensure fair review of matters that get brought before. If confirmed, I will conduct myself impartially, and I will apply the law of the Commonwealth with both integrity and compassion. I will work to add capacity to the housing court, who serve numerous self-represented litigants, and to both support and share my knowledge with staff to help them guide litigants towards equitable resolution of their cases. In closing, I'd like to take a moment briefly to thank my mom, who's probably watching today virtually, to my father, who I hope is watching down on me from above, my siblings, and to the many individuals who supported my nomination. I want to especially thank my wife, she's an amazing partner and a gifted attorney who is here today with me, supporting me, as well as my two children. And I want to particularly thank my youngest child, whose birthday it is today, and who is still willing to share me with you this morning. So thank you again for this opportunity, and I'm happy to take your questions at this time.
Thank you very much.
Thank you.
I'll start the hearing with questions from our elder counselor and 20-year member, Marilyn Petito-Devaney. Councilor Devaney, do you have questions for the nominee?
Thank you. Nice to see you again. Thank you for coming in to see me, and I appreciated the time. I had it before hours.
I believe so.
I appreciate that, because very important for me to know the whole person, not just someone on a piece of paper. I like the idea that you know another language. I think that is a very valuable asset in the court. Now, okay. Now, one of the things, and I asked your witness. I haven't seen this before. You have not had a trial. Now, you told me that in person, and I'd like you to, in public, to tell my colleagues and people who are, watching, why you feel that it wasn't necessary for you to bring that to the bench.
Thank you for the question. First, I'd like to say that as the witness talked about, I had a tremendous amount of in-court experience. That would also include preparation for trial, and that has allowed me to also get a strong handle on what the requisites are for having a trial. Evidentiary rules, court process and court procedure. I've had opportunities to argue substantive motions, both at evidentiary hearings, as well as substantive motions that resolve the entire case, summary judgment or judgment on the pleadings. Well aware and versed in this area. I'm in court weekly. So the question is not as a result also of my practice, skill, and ability. It's not that I can't have a trial, but just a trial has never been necessary in my cases. For the fact that I've been able to either resolve them before trial, either by resolution, or I've been resolved them by matter of law before the court in procedural.
In your experience, how many years is it that you've been in the housing court?
I've been at Greater Boston Legal Services for 20, in the housing court, practicing legal tenant law, somewhere in the ballpark around 12.
Okay, so 12 years in the housing court. In your experience, what would you, as a judge, like to change in the housing court or improve?
Certainly. The housing court has made many strides in addressing the large number of self-represented litigants that come forward. And by making both the court more accessible and putting in additional services to assist the parties in trying to address what often are accommodations. I would continue to work with the staff to improve on the staff's ability to creatively think of and reach resolution between the parties based on my experience. And as Attorney Katherine Downing had mentioned, my experience not only covers landlord-tenant law, but what I bring to the table is also significant knowledge in federal and state public, subsidized, affordable housing, tax credit housing, as well as knowledge of our state's shelter program. And I have used that knowledge not always in an effort to try to preserve housing, because sometimes that's just not possible. But there are other ways to address this and to address the clients, both parties' concerns, while also ensuring that families aren't left homeless.
In your 12 years, does one case stand out that you're most proud of?
It's a good question. I'm just trying to think. I've had a fair number of appellate work, and my answer to that would be yes. I had one particular case that involved again disability-related issues with a single parent, and I was still sort of getting grounded in the practice of landlord-tenant law. And I was very pleased that I was able to bring that matter before a single justice of the Court of Appeals and actually be successful in helping this individual retain her subsidy, address the disability-related needs that she had, and continued that she would not be rendered homeless.
Great. What was the most disappointing?
Similarly, I had a case in the Court of Appeals that I tried all the way through up to that I worked all the way through up the Court of Appeals, and it involves what often is a situation where there are drug-related criminal activity in the unit, and you may have one bad actor, and that one bad actor may unfortunately result in an entire family losing both the subsidy and the housing. At times, I can be successful in being able to at least remove the bad actor and preserve the subsidy. Sometimes that's not, I'm not successful. And in trying to argue that as a matter of law, this family should have retained the ability to continue their voucher, I was not successful in convincing the appeals court with that case. And it is a case today that continues to come back to me in the work that I do every day.
In your experience, what have you learned not to do from an unfair judge that you were before, and then tell me what you learned about the good judge that you were before, the fair judge, I should say.
Certainly. I mean, as a matter of practice, it's always good to know when to stop talking, when not to interrupt a judge, when to understand when there is the need to provide background, to provide context for the judge and context for the law. And so it's always important to pick up on those cues that may happen. With judges who have a little bit more a handle on perhaps the cases that are before them, it's always incredibly important to be prepared, because they may jump 2 or 3 steps and they will get right to the heart of the matter. And they may ask questions that haven't really thought of. And I think that's a hallmark of a good judge as well, having to actually taking the time to learn the case, read the case, understand it, think about it, and know what kind of questions to ask to get right to the heart of it.
You know, we don't hear very much about, housing court. We hear about, district and superior. And to me, the need for housing is growing more in our society. And I served on a city council for almost 20 years. And those are the calls I get. In fact, they still call me. It's a great need. Now, there's legislation. I've been following it, and it's going to expire in August, but it looks like it's going to be renewed, about allowing tenants, about, the that have not paid rent and so forth. Tell me what your opinion is on that.
So just by way of context, again, as a associate justice in the housing court, it would be my role to apply the law, whatever the Commonwealth decides that is to be. More specifically, in this case, that is correct that there is a current moratorium that was in place, and my understanding is that Governor Baker decided to extend the moratorium that's actually has already been enacted. I think it's potentially by 60 days. I believe that it is important to have that in place for the time being to not only protect tenants, but the moratorium also extends protection for homeowners. It also extends protection for small businesses. But that alone is not going to be sufficient. And my understanding is that in reading the materials from the governor, that they have also, and in looking at the governor's past actions, that they are also looking to try to address the underlying issues that have caused the systemic problems of unaffordability of housing, loss of, the consequences from the pandemic, loss of work, loss of rent, loss of housing, and there's efforts underway to try to address those underlying issues so that once the moratorium is lifted, then relief can be provided across the board for everyone.
Now, hypothetically, say that there is a two-family landlord in one apartment and a tenant in the other. Is there anything, for that landlord that he won't have a foreclosure because he can't meet the payment for the mortgage because he's not getting a rent? How is that? How does that balance?
So there are both, that is correct. There are protections that are in place, either going through state legislature under the current enacted moratorium, possibly also under the CARES Act and the federal, that allows for possible either forbearance or deferment on the mortgage. And as indicated, Governor Baker had recently announced additional funding under an emergency program that also targeted households, homeowners, I should say, and had also increased the income eligibility threshold for for individuals so that they would be able to qualify. And so they are also providing financial resources. So you have the combination of protection under law against foreclosure and the combination of financial assistance to be able to catch up on the missed payments.
Now, we know there's so many families that are paying even up to 50% of their income on housing. And right now, there's so many people that I know. I even have a son that's out of work, and he's not in that category, but I'm just saying that, there's so many people I know that are out of work. And I'm just saying that with this, and also on the other side, the housing costs, how they have risen. How do you balance that? How would you balance that as a judge? You got evictions, you got people who have foreclosures, people who want to buy a home, and with the rising costs. I mean, I could not buy the house that I live in, and what the houses are going for in my little town is ridiculous. I mean, some of them are going for $1 million, and 10 years ago, they probably would be 300,000. I mean, really, literally, and I'm sure you're seeing it in the different communities. Now, I can't believe you got an awesome responsibility to be a judge on the housing court. I don't think people really think they need housing. They don't know what's involved in all the things. And honestly, I was very impressed and all. I'm not going to go into all your cases, but I was very impressed. And, I want you to address that if you can remember what I'm saying, because I do go on, I don't mean to. But, one of the things that I look for, besides experience, besides qualifications, is empathy. And you have it. You have empathy and compassion, and that's important to me. And you weren't born with a silver spoon in your mouth, and all your relatives aren't judges and so forth. And, you came in here on your own, and I appreciate that. But I do want to know, how do you meet this challenge of our housing situation?
It's again, very important issue, Councilor Draney. The number of, I completely acknowledge and concur that the degree of rent burden that individuals are struggling with is high. The affordability of housing is high. And we have seen many efforts, both across the state and locally, trying to address that issue and trying to increase the volume of affordable housing across. What I would say from the standpoint of an associate justice counselor is that I both understand and empathize with the impact that happens on both ends, where you have a family who could potentially become homeless, but you may also have a owner-occupied small-time landlord who may lose their home. Both parties, in fact, have an interest in being able to count on one another, if you will, for their mutual benefit. Owner-occupied landlords need renters, and renters need a place to live. And in fact, owner-occupied units within the tenant advocacy community is extremely important, because what we see is that those owner-occupied units provide unique opportunities for perhaps first-time renters, opportunities for below-market rent, because maybe some of the landlords, which my mother and father were landlords also, and we would look for good renters, charge them less than below-market rate to ensure that we can have a long-term sustainability. The loss of a owner-occupied unit is a big loss for the housing stock within the state, and often what we're seeing now, and there's information out of the Boston Federal Reserve that indicates the housing is being bought up, not by individuals, but by real estate corporations or other business entities whose focus is a little bit different than what would be an owner-occupied unit. So we have a strong interest, Councilor, and yes, in being able to not only avoid homelessness, but also to preserve these small-time landlords, owner-occupied units for the sake of tenants as well as for the owners.
I mean, I see it in where I live, and I see it in all the surrounding towns and cities. You've got these big developers, and they'll buy this little house, they'll demolish it, and they'll, have an outrageous price to sell it or rent it. So, I mean, you can't do anything about that. I just want to say that. But, I'm concerned about people who have vouchers. And I've been involved with a lot of people who, who do seek vouchers. And I have to tell you, last year, I lived on the next street from a housing project. And there were people that stayed overnight. Some came in buses and sitting on the curb and waiting for morning to apply for Section 8. And I know it changed now. It was well over a 5-year wait. That wasn't that they were getting on a list right away. That was a 5-year wait. Now, we did have another program that was maybe before even, you were in the housing court, and now that's gone. And so now these people have to wait 5, 7, 8 years. Do you see any chance of we would get a federal voucher to help people to, to be able to rent that apartment and have it, subsidize that rent?
Again, just speaking from my experience, I acknowledge and agree that the ability to obtain either a federal as well as a state tenant-based voucher has been extremely difficult. The wait time has not improved any since the time that you saw that incident happen. And what's become even more problematic, Councilor, is the other issue that you alluded to is the cost of housing. And so what you're seeing now is that because of the increase in cost of housing, you're actually seeing housing that is beyond the ability of renters, even with a federal voucher or a state voucher. So not only are you, or should I say tenants or potential renters struggling to try to obtain a voucher to be able to afford permanent safe housing, but then they risk losing the voucher if they are unable to find a suitable home that's within the specified range for them to be able to rent.
Well, we talked a lot in the 4 hours. I found out a lot about your background. Tell me how
not to be, you don't have to get personal, but how do you feel? Because I look for life experience. That to me is important to bring in the court. You have it. You have that life experience that I look for. So if you don't have to get really, really personal, but can you tell us why the housing court is such a fit for you with your life experience?
Again, I'm able to empathize on both ends. You know, as my parents, I spoke earlier, you know, my parents did not come to the United States immediately as homeowners. They had to work hard to save up their money, and in that time, you know, they needed opportunities like others to have to rent, have access to housing, affordable housing, and as owners themselves, they paid it forward, if you will, and also provided the same opportunities they were given to other potential tenants, below market rate rent, and being able to have that stability. And I've seen the struggles that both my parents had as they were sort of moving along in their lives, and I've seen their struggles as an owner as well. Oftentimes with tenants who were unfortunately they weren't bad tenants, they were just tenants who were again had a life circumstance, a loss of job, an injury that would often prevent them from paying rent, and that has to be taken into account. And so again, I'm able to kind of empathize with both ends and appreciate the challenges and difficulties that folks have in being able to search for housing, provide housing stability, and also empathize with the owners who are trying to hold on to what they have, who've worked hard for it.
I just want to ask this last question. The courts have been closed, and they're only open for emergency, you know, cases. If you're appointed, what will you be doing? Will you be going to court? Will you be, I don't know, with all this technology, Zoom or whatever, what will you do when you are appointed?
Well, Counselor, I would say part of that is up to the Chief Justice. However, what I can say is I will hit the ground running. Because of my background, experience in housing, extensive experience in public and subsidized housing, I'm able to hit the ground running to be able to start to address the backlog that's existing currently in the Housing Court Department. The Housing Court Department is still processing cases. They're under the moratorium, they're still allowed to process what they call essential cases, cases involving health or safety risks of the residents. So those cases are still being addressed virtually. In some cases, perhaps in person, but they are being addressed virtually. And so my assumption, again, would be that I would be participating and engaging in presiding over virtual cases.
Thank you very much, and thank you for all the time that you afforded me. I really appreciate it. It means a lot to me, too. Thank you.
Nominee. Councilor Jubenville, do you have questions for the nominee?
Thank you.
You're welcome. Nice ties.
How many times have you been before judges in your career, approximately?
It's a very large number, Counselor.
Hundreds?
More than hundreds.
Thousands?
I can say to you, sir, that I've appeared pretty much in every type of court in the Commonwealth except within the Supreme Judicial Court. I've appeared in District Court, Superior Court, Probate and Family Court, Housing Court. I haven't appeared in Juvenile Court, so I'll take that one. That's the other one. And I've appeared also in administrative hearings, both presided over by state departments, state agencies, and non-state agencies.
So it's fair to say you've been before judges thousands of times.
Yes, sir. And as a housing attorney, I would be in court nearly weekly.
Some people say there's systemic racism in our court system, sometimes knowingly and sometimes unknowingly. You agree with that?
I agree that there is implicit bias that exists. I do agree with that. I agree that there is implicit bias that exists. Again, as you had indicated, Councilor, whether intentional or unintentional, but we're looking at what the results are and being able to look at what the data is on the ground. If we're looking at situations that you're having a disparate impact, not just necessarily because of results of the court, but also what's happening in society as a whole. So an example would be, recently there was a report that was issued by City like Vida Urbana that talked about disparate impact on communities of color. It's important to understand for me, I think, that because that's the individuals who you're going to see who are now being before you in court systems. So sometimes it's not necessarily you're seeing that systemic issues, not just sort of within the court, but being brought into the court.
Well, how do we stop that? If you become a judge, how do you stop that?
I think part of it begins with being able to recognize and begin with self. Counselor, to be honest with you, being able to recognize, even as myself and in my humble beginnings, I also do come to this table with a level of privilege. You know, I have an education. I'm an attorney. I may be one of the first in my family to have achieved a college degree. I may be the first in my family to have a law degree, but that allows me a certain level of privilege. I can't identify with someone in this country who may be under DACA, who may be under other immigration status, who are trying to figure things out. There are certain things that I have not had life experience with that others are having experience with, and those challenges. So it's important for me to be able to understand not just my level of privilege, but how the scope of my life experience, to understand that there are other experiences that I'm not aware of and need to be conscious of.
Yeah, I believe there is too a lot of systemic stuff built into our court system. You think we should be doing more of education with judges on that issue?
Yes, sir.
Maybe if you become a judge, you can raise that to the chief judge of the housing court.
Yes, sir.
What do you think is the best quality of a judge?
Patience, practicality, in my opinion. Patience for the fact that you want to have litigants feel like they're heard and understood. Practicality in the sense that you need to be able to not only understand the law, but cut through the issues to get to what the heart of the matter is and understand what the goals are. Sometimes in the heat of the moment, you get caught up in emotion, and caught up on feelings that that may bring you into a more principled position. But it's important to keep your eye on the ball with respect to what the goal and the outcome, what the goals are of the litigants, and trying to help steer the litigants towards that direction. And so, again, patience and practicality for me is the most important.
What do you think is the worst quality of a judge that you've seen?
I think for me, what's important is to have a appropriate bedside manner or bench manner, to be honest with you. Not only because you're dealing with a number of self-represented litigants who do not know the process, they are there, scared, they probably have never been in court at any point in time in their lives. They don't know the process, they may be self-represented, but there's an attorney on the other side. I also remember, as you probably remember yourself, Counselor, I wasn't always at this point in my career in terms of knowing as much as I know. I had to start somewhere also, and I'm sure I made plenty of mistakes, and I'm grateful for the judges that extended to me, their patience and their kindness in being able to walk me through the process and not just make assumptions about what I know or shouldn't know.
Have you ever been criticized in the courtroom by a judge?
No, sir.
Have you ever seen judges criticize anybody in the courtroom?
There are judges who will point out certain mistakes that individuals are making, or they're not aware perhaps of whatever the court policy might be or court protocol might be. And so in that sense, I've noticed that. I've not actually seen in terms of criticism, no.
You're lucky.
We have a great bar in terms of the justices of the housing court. They're, I'm privileged and happy that I'm being able to practice before them and potentially serve among them. It's why I think I felt very much passionate about housing law, not just because of the issues that we're dealing with, but because we have, as you can see, I'm blessed to have landlord attorneys who support my nomination, and that's been because of the great relationships that we have within the bar. And I also have had great relationships with the judges, and I think that that's what's really important in order to be able to have a congenial environment and be able to stay focused on what the business is at hand.
Have you seen judges fine any lawyers?
Not in my experience, no.
Have you ever heard of it?
Heard of it? Yes, but anecdotally, just through talk.
Have you seen judges fine people for coming in dressed inappropriately?
No, sir.
Have you heard of it?
No, sir.
Is there a dress code in the housing court?
Not formally, sir.
What do you mean by that?
There is not a formal dress code, but there is an expectation, or I think some understanding that if you're going to appear in court, that you should be dressed appropriately.
What does that mean?
Not everybody.
A suit and tie?
Well,
man.
If your role is counsel, absolutely. Always have suit and tie ready. If you are not in that particular role, to have appropriate wear that may not have holes in it. Look presentable. Doesn't need to be a suit and tie, but just sort of being able to, you certainly don't want litigants necessarily, I would say, walking into the housing court with pajamas. But dress appropriately as they would.
So if a litigant comes before you, you're sitting on the bench and they come in with their pajamas, what are you going to do about it?
I may raise it to their attention.
Why?
I think it's a matter of having some consideration for the court.
Well, are you going to do that in open court?
I may explain to them in open court, certainly, with compassion and empathy, absolutely, because at the same time, I have no idea what those circumstances might be. It may be a single parent who has just sort of barely had the opportunity to put their child on a school bus and jump on a public transportation to arrive in court, and that's what sort of their morning was. So not to make any assumptions, but also in inquiring about it, there might be other information that's important to know.
And where would you do that?
In colloquy.
In open court?
Yes.
Well, that may embarrass somebody standing there, right?
It's all in how you do it, Your Honor, sir.
Well, what if they say to you, Judge, I don't have any money for those. In fact, I'm here today because the landlord wants to throw me out of my apartment with my children because I'm not paying rent.
Then
I don't have any money.
That would be information that would especially be important for me to consider, not only because of these considerations with regard to housing, but there may be considerations with regard to what are the children's needs.
Well, I'm talking about the dress, so stick to the dress.
No, I understand, but what I'm saying about the dress is that in being able to inquire, as in your example, that may lead to other information that I think is also important. If in fact, as you're saying, I'm here before the court dressed in a particular way because I lack the particular sort of funds to be able to have clothes for myself, be able to provide for my children.
Why would the person have to disclose that in front of all the people in the courtroom? Wouldn't they feel kind of embarrassed about that?
Understandably, but also you need to remember that.
Well, if you say understandably, why would you want to embarrass somebody in your court?
I don't want to be taken out of context, Counselor. I'm not suggesting, nor would I ever embarrass any litigant before the court.
Well, you would if you said to somebody about their clothing,
No,
and
sir.
having them have to say, I don't have any money to buy clothing.
Let us remember in the example that you're giving, Counselor, they're more likely to begin with for a non-payment of rent. So they're already before the court regarding their lack of payment or lack of ability to pay rent. That would be an inquiry that I would be making regardless about their financial
Yeah,
circumstances.
but that would be about the rent, and that's why they're there. It would be about a personal issue about what clothes they can afford or what type of clothes they even wear. Wouldn't it?
No, I think it's not a matter of Counselor getting into the weeds about the type of, about, why don't they have, or why do they choose the particular wear that they did. I think it's important to maintain a certain decorum within the court. It may be important to get that across or
Well,
explain that to.
Here's the question. Is there a rule or regulation or a statute in Massachusetts that regulates the clothes that somebody can wear into a courtroom?
Not with respect to litigants.
So why would you as a judge be even concerned with what they wear unless it was some offensive type clothing?
That is what I'm actually talking about, or if they are appearing in a way that may detract or draw attention unnecessarily or inappropriately, then there may be a need to address that particular issue. It really depends on the circumstances.
Well, I would disagree with you on that. I don't think it's a judge's business unless somebody comes in with some sort of a T-shirt that says "kill all judges" or something that's offensive in nature. Not just offensive because you as a judge don't like their type of clothing they wear, like you said, pajamas. I see a lot of people coming to court in what I believe are pajama wear. But I also know that there's a lot of similarity between pajama wear and what other people wear, thinking it's okay to wear outside. But if you're going to, and I haven't been in the housing court in a good many years, but I know it's a very busy court with a lot of litigants on both sides in that building.
So
the courtroom's full of people, right?
yes, sir.
You're going to start getting into how people are dressed. You're going to spend a lot of time in your courtroom talking about dress wear rather than talking about the issue as to whether somebody can afford to pay rent or whether they broke a lease, aren't you?
That would not necessarily be my primary focus, sir.
Why would it be any of your focus? I don't get that.
And I think I've covered that. I think it really.
We haven't covered it enough for me.
Understood, sir. And
Because
again,
I don't think a judge has any right to question what somebody wears to a courtroom. If there's no dress code for the court, there's no rule or regulation.
yes,
It's
sir.
none of the damn business of a judge what somebody wears. Again, unless it's sort of out of the way offensive. I've seen people come in courtrooms with T-shirts with no sleeves and a pair of shorts. And I've seen judges criticize them up and down in front of a courtroom full of people. And you know what I think when I sit there? This judge is nothing but a bully. That's what you do when you criticize in front of people and embarrass them in front of people. In my view, you're a bully.
I
And
agree.
you shouldn't be on the bench, in my opinion, if you're a bully. Don't you agree with that?
I absolutely agree. And that's why I said how you approach things absolutely make a difference, not just in that circumstance, but in every circumstance. And as we were talking earlier before about sort of implicit bias and so forth, it's important to check your assumptions at the door as well. And so that's why I say the fact that I'm raising it or having a discussion about it does not necessarily relate to the manner in which I would. There is a need to be compassionate, a need to be empathetic, a need not to have any type of assumptions that are coming into it. And in having and approaching it that way, you may actually result in other facts that are particularly important, such as in the example that you gave. If I have a litigant who is talking about how they're not just having trouble paying rent, but there are other issues, and I have an opportunity at that moment to be able to call perhaps a housing court specialist to sit down and be able to talk with that person, not just about the housing related issues, but perhaps they may have issues related to, are they receiving transitional assistance? Are they having trouble with their child support? Are they having trouble accessing mass health? Are there any other services the court should or could be providing, not just to address the housing matter, but to address the life matter? And that's one of the ways that is the way that I have practiced consistently, is holistically. If you find that there's one area in a person's life that may have some type of shortcoming, it often has a cascading effect. So when I look at an individual and I talk to potential clients, I'm able to look at the whole person, address the issue of income, maintenance, housing issues, health issues. And I think it's important to, in my opinion, I've been grateful to have the background that I have to be able to inquire about those different things and look at the person as a whole person.
I get all of that. That's all good stuff. I'm talking about dressing somebody down or criticizing them in a courtroom because of what they wear.
I agree, and I think we're on the same page with that, sir.
So you won't do that.
No,
And if somebody has offensive closing, you have a court officer in your court, don't you?
right,
So you can say to the court officer, come here a minute, that fellow over there has got something. We can make him go out and turn that shirt inside out or something.
that's true.
Or ask
And
him to do it, right?
I have seen housing court judges do address,
So that way the person isn't embarrassed by the judge.
understood. And I agree with you, but as I said, I agree with you in the sense that also how you handle it is extremely important. You don't want to make someone feel less than, and I'm with you on that.
Then I'm going to suggest that since there is no code, you don't even bring up the way somebody's dressed.
Yes, sir.
You should assume if they're dressed a certain way that that's all they have, or that's all they were taught to dress. Maybe they were never taught by their parents how to dress. Maybe they dress differently than you and I would dress because of some cultural thing.
Right. I do want to sort of draw a certain line, though, Counselor, that when we're talking about the context of dress, we are talking, like you said, something that would be over the top, if you will, offensive, what happens. That we're not talking about your everyday type of dress.
Well, I hope not, because I think it's one of the worst qualities a judge can have.
And I would agree. Any judge who
Get involved. I've seen judges fine people. We had a judge in here who said that she was going to fine people that came into her courtroom dressed inappropriately. By inappropriate, she said, just inappropriate. I said, so inappropriate by what you think it should be dressed. But there's no rule or regulation. She said she was going to fine.
I think, sir, you and I would be on the exact same page on that issue.
It's a busy court, and the lawyers that work there have a lot of commitments. They work hard. They go to different courts sometimes. And they get to your court late for second or third call. How do you feel about that?
I feel that it's important to give still the litigant the opportunity. I see that consistently in the housing court, and for reasons similar to the example that I had explained to you, that you have litigants, self-represented litigants, who are trying to meet a schedule. They need to drop children off.
No, I'm talking about lawyers that have a case in front of you that day. They call the clerk's office and say, would you make sure the clerk knows that I'm going to be late getting there. I have another commitment in another court. Would you ask my case be held for second call?
Do I have an issue with that, is your
Yeah.
question, sir? Not at all.
You do know that lawyers have to make a living, like you did as a lawyer, right?
Yes, sir.
Some judges get on the bench and they forget that lawyers have to make a living, even though they had to do it when they were a lawyer.
Judicial temperament and how I address litigants, attorneys, treat them is extremely important to me, Counselor.
How's your temper? Have you ever lost your temper?
No, sir.
You've never lost your temper once?
Not in court, no.
Oh,
But and any time I have, as you can see, my better half.
I'm going to tell you, if you've never lost your temper, you are one unusual.
Well, like I said, it's when I have an attorney as a wife, losing my temper, it never really works out very well. So.
No, it doesn't. But some judges lose their temper on the bench. I've seen that.
Absolutely, as have I.
It's bad luck. It means you've lost control of yourself.
Going back to one of the questions, Counselor, that was asked about the particular values or qualities. That's why I say number one, patience. Absolutely.
Patience is, once was said, it said, patience is the virtue.
Yes, sir.
If you have that, you'll have the other virtues. But patience is the number one virtue.
Agreed. Agreed.
And for a judge, you're going to be listening all day long to people. And judges that talk too much usually get in trouble. People aren't there to listen to you ramble on and tell all of your knowledge to people.
I completely agree. My goal would be to want to have the court be accessible, to have litigants feel heard, feel understood. They may not always like what the decision and the outcome is, but at least I want the experience for them to be something that they can say felt meaningful and that they felt they had an opportunity to present their cases. And that's all litigants, whether it be attorneys, self-represented litigants. As to the attorney issue, as I said earlier, Counselor, I started once at a beginning, wasn't perfect, and I'm grateful for those judges who extended patience, courtesy to me, as well as other attorneys who extended the same patience and courtesy.
You said this moratorium on rents is a good thing in your opinion?
I think that the moratorium on rent is necessary for this particular time. And actually, let me be more clear. Moratorium on evictions, moratorium on foreclosure, moratorium on also eviction for small businesses. More specifically, even, I would say that the protection that we're talking about for these particular entities, renters, homeowners, and small property owners, at this time is extremely important.
As I understand the law, or maybe I don't understand it enough, maybe you can fill me in, please. Does it mean while the pandemic's going, I don't have to pay rent if I live in an apartment?
No.
Under no circumstance does it say that. In fact,
What does the law say?
the moratorium currently enacted as it was drafted, in fact, if I'm not mistaken, in 2 separate sections, make it very clear in no uncertain terms that you are still required to pay your rent. And I believe that same language has been captured by the Attorney General, or excuse me, not by the Attorney, the Department of Housing Community Development, who promulgated regulations to that effect as well.
So even though there's a pandemic and you're in an apartment and you've lost your job or your job has been put on hold, so to speak, you still have to pay your rent?
Yes, sir.
Well, how are they going to do that if they don't have any money coming?
I'm distinguishing between the ability and whether the law gives you a pass. The law does not give you a pass.
So it's if you have the inability to pay, you can't be evicted.
Right now, under the present moratorium, they identify protection for what they consider to be non-essential cases. And within the definition of non-essential cases are cases that would be brought for non-payment of rent.
Okay, but if I have the ability to pay, I have to pay.
Yes, sir.
If I don't, for some reason, I'm a bartender, the bars are all closed. So if I don't have the ability, I get the protection of the law for being evicted.
Yes, but just to be very clear, you may get the protection of the law to that would prevent an owner from commencing an eviction action, but you are not given a pass, if you will, on the payment of the rent.
So that rent that you don't pay for those months, you're still going to owe at some point?
Yes, sir, under the current legislation, correct.
Okay. Do you think it's fair to landlords, that law?
I think it's fair in the sense that it provides them also the same type of protection that's necessary.
How do they get protection?
Because they are also protected in the same form as the tenants, in the sense that they have protection against foreclosure. So they won't, the bill will still become due, but banks are not permitted to commence and initiate foreclosure action under the current legislation of the moratorium. Same applies also for, like, if I'm not mistaken, certain nonprofits and small businesses.
So the banks can't foreclose on a landlord that doesn't pay his mortgage because he's not getting rent from tenants? They can't foreclose?
Whether it be not getting rent for tenants or because they themselves lost their job. That is my understanding. That's under the current enacted moratorium and legislation. Right.
Do they still owe their mortgage payments and will have to pay it back at some point in time?
Yes, sir.
Let me ask a hypothetical. During this pandemic, somebody's in an apartment. They're under a lease. The lease says, when it's over, well, during the lease, if they're getting ready to go, they've got to let somebody in with the landlord to look over the apartment. The landlord wants to rent it to somebody else, and he says, I want to come in the apartment. I want to bring a new tenant to look at the apartment. The tenant says, I'm 65 years old. I got underlying issues. I don't want anybody in my apartment. Landlord files a eviction notice, breach of the contract to allow me to come in and show the apartment. It lands in your court. You're sitting there. What do you do with that?
So, 2 things. First, just to, not to be hyper-technical, that would not be considered a case. My feeling is that would not be considered a case that would fall into the non-essential.
Okay, yeah, I get that, but let's assume it fell before. Right. And the facts are very simple. They're not behind in rent. Their lease is expiring in a month. and the landlord wants to bring in somebody to look at the apartment.
We can't.
Again, my mindset is on what is to be goal oriented. Not only would the lease provide for that, but statute allows for that as well. I would be considerate of the individual and of their underlying health conditions, and I would try to mitigate that as best as I could.
Well, how are you gonna? She says, no, I don't want anybody in, and the landlord says, yes, I want somebody in. You gotta make a decision.
That is true, but I think that it's a decision that also offers for opportunity to conversate. I think you need an opportunity to talk a little bit further and say, okay, I acknowledge what their concerns are, acknowledge all of that stuff.
It's been talked out in the hallway. It's been talked everywhere. It's talked itself to death.
Right.
They're before you to say, can I bring somebody in this pandemic with a tenant that's got underlying issues, or can I not? Simple question.
The answer to the question is, I believe I would have to require that the tenant allow for access, both under the contract of the lease and as well as from the statutory. That doesn't mean, though, I wouldn't require certain provisions that anybody who enters the unit has to enter the unit with masks, perhaps with proper PPE. They should attempt to discuss the opportunity with the tenant to see if there's a time perhaps that the tenant may not be home, in order to do the inspection of the unit. I would also talk with the landlord to see if there are other alternatives. Say, for example, in order to avoid having to do repeat showings, is it possible for the landlord to come in and take a video, say, of what the apartment looks like and be able to then present that?
So, 65-year-old woman with serious health conditions, you're going to let that landlord go in with a tenant. And the 65-year-old woman has no idea where this prospective tenant has been, whether this prospective tenant has COVID-19. You're going to allow that in. Well, and I hear that. Would you allow it in if it was your mother in that apartment?
Again, it's not a matter of who is.
No, I know, but look, we have people dying all over the Commonwealth. We're the fourth highest death rate in the United States for 6 million plus people. People aren't being thrown out of apartments because of the pandemic. They're on hold.
Right.
And you're going to make a ruling that somebody can go in and this woman can possibly be infected by this?
Well, again, we're talking hypothetically. Again, this would not be a case that would be brought or could be brought under the current moratorium.
No.
And I just want to be clear
on
on that.
But also, I'm talking about your decision.
Right.
You said you would allow it in.
I said I believe I would need to allow it in, Your Honor.
Why?
Because again,
You're not going to throw people out of the apartment because they're not paying rent, because they don't have a right to pay rent.
I think we're.
Or they can't afford to pay rent. You're not going to throw them out for that, and that's because of the pandemic.
But again, I think what's challenging about your question is that in your hypothetical, you're not applying the moratorium, but now you're using the moratorium as a way to say, I can't allow people who don't pay rent. What I'm saying is that if we want to be fair and equal, right, put in the same way, if I had a 65-year-old individual who had underlying health issues, hadn't paid rent for 6 months.
Doesn't leave the apartment either.
Right.
House file.
Would it be challenging to evict that individual? Absolutely. Would I empathize and feel a certain way about having to do it? Absolutely. Does the law require me to have to do it? Absolutely.
You think that's a fair law?
Depends on your point of view. If you're a homeowner who's looking for that rent to pay your mortgage, you would think that that is extremely fair law.
There are laws that judges agree with and judges don't agree with, right?
Right.
And if you thought some law was really egregious, you just didn't believe in it at all. It was unfair to the citizens of this town. You would enforce that law?
I'd be required to.
I disagree with you. I disagree with you 100%. You can make a ruling against that law and let them appeal it. And let the SJC or the appeals court decide what's fair and what isn't. Can't you?
There is the question of precedent, Counselor. You're aware of.
No, you know what? There's a question of being bold and being concerned for the citizens of the Commonwealth and enforcing a law that you feel as a human being and as a lawyer is totally unfair, to me, is not a good decision to make for the people of the Commonwealth. You're a judge. What happens if you make a ruling on a case you know you're going against the law? What happens to you?
What happens, Your
Yeah,
Honor?
to you personally.
To me personally, not having been a judge, I can't answer that question. But what
Well,
I
I
can,
can. Nothing.
if I could, Counselor, as a litigant though.
I'm not talking about litigant. I'm talking about a judge.
Right, but I do want to address your point in this respect. Bad cases make bad law. And if you have a ruling that gets brought up, and that ruling gets published, then what ultimately happens in that particular case is that, and I can tell you from personal experience, having had an appeals case that did not go in the way that I wanted to, and that appeals case now is appearing every single place that when I bring up these same issues. You have a,
Because why?
because it had a broader impact.
So? Isn't that what the appeals court does all the time in the SJC?
But I could be creating a bigger problem
So what?
for the sake of not.
You're not
following the law.
creating it. You're making a ruling. It's going up to a higher court. There may be a reason, a good reason why it was changed.
Sure.
They may look down and say, boy, judge in a housing court, I'm glad he ruled this way because this law has got to be changed. And the SJC changes it. You'd feel pretty good about that, wouldn't you?
If I had good reason to, in the sense of actually argue that there isn't a
What are you
basis.
talking
for the law.
about? You ruled the way you thought was unfair. The SJC upheld you and said you were absolutely right to make that ruling.
Unfair as a matter of law, yes.
The SJC, said you went against the law. You were right. The law was bad. We're changing it. Wouldn't you feel good about that?
Yes.
So what's the downside for you to rule against the law you think is unfair to the citizens of the Commonwealth?
But again, is it unfair? Are we talking about sort of it unfair because of particular circumstances, or is it unfair because as a matter of law, there's something wrong with that law legally? It goes against the Constitution. It goes against federal law. I mean,
Who cares about federal law? You're not a federal judge. You have no concern with federal law.
As a housing court justice,
Yeah.
you do actually have cases before you that you have to interpret federal regulation and statute.
You enforce federal law?
I have to follow federal law and statute. If you're dealing with a federally subsidized unit, yes, sir. If you're dealing with a Section 8 tenant-based voucher, yes, sir.
Why? I don't know why you'd want to do that. Okay, so in public housing, if a tenant is found to have marijuana in his unit, legal marijuana, housing court says, a housing development says, you're getting evicted. You're not supposed to have that. What do you do with that?
Depends on, and I'm not trying to dodge the question, it actually depends on what type of housing that you're in. Let me explain a little further. If you are residing within a federally subsidized public housing property, under federal laws, I'm sure you're aware, they still consider marijuana to be a illegal substance, and they mandate, and that the housing provider has discretion in which to proceed to evict. Under state-funded public housing, it may be a little different because we allow for certain opportunities to possess within a certain quantity marijuana. And so those are the inquiries that I think that are important to have to make. And that's why one of the inquiries that I'd be able to bring to the table. I understand the distinctions. I would be able to ask the questions and say, what kind of housing are we in? What are the amount of marijuana did you have on you, in order to make a proper assessment as to whether or not the housing provider, in fact, had the ability, had standing under both law and lease in order to bring that action.
So the Boston Housing Authority, is that federally funded?
They have both, sir.
So they would have a provision in their leases that you can't bring illicit drugs into your property?
They have a provision in their lease that specifically identifies and explicitly says it is not permitted to have any illegal drug activity within the unit, either by the tenant, household members, guest or anyone under the guest's control.
Okay, so the tenant has the marijuana. Housing authority says we want to evict him, judge. He's got marijuana.
They would be within their rights to bring that case.
And you would evict him?
Again, we'd have to talk about circumstances, how much marijuana.
No, it's all legal. Everything is legal. There's nothing, he's got a roach, smoking a roach. It's legal.
Again, I mean, there's a couple of different things on that issue. I have seen plenty of marijuana cases. What I see with respect to the Boston Housing Authority, who I have a lot of respect for, one, to be honest with you, they probably wouldn't bring a case in that respect. But what are the cases that they're looking for, and the cases that you actually see in the housing court is less a question of possession, more a question of distribution. So just to be a little bit more specific and give an example, what you're looking for is, are you looking for quantities? Are you looking for, are they individually packaged in a certain way? Do you see, I don't know, digital scale seems to be pretty big.
My question is simple. The person's got, I'll make it even easier for you. The person's got medical marijuana in there from a doctor authorizing it. Housing official says we're bringing a violation of the lease. He's got illegal drugs in there under the federal law. We want to throw them out.
So the answer to that question is that under a federally subsidized property, I would be required to permit an eviction, even if they are seeking a disability-related reasonable accommodation. Under state federal housing, I have more discretion.
So under the federal subsidy, medical marijuana is illegal.
Yes, sir.
And you would throw the tenant out.
I would have to.
No, you wouldn't have to. You would make that decision. You're free not to make it. You're free to turn down the landlord, right? Aren't you?
I'm free to yes. I mean, yeah. Technically, yes, I could rule.
So you're going to throw out this person. Probably get kids that live there with them. They're all getting tossed out. This person's got medical marijuana. And you're going to do that to citizens of this Commonwealth. As you said, I have to.
I think it's one of the difficult parts about being a judge.
I don't think it's difficult, that question. If I was you and I was a housing judge and that came before me, I would not throw people of this Commonwealth on the street. I would rule against the tenant, let him take it up. Let somebody else make that decision. Let somebody be the son of a bee who's throwing these tenants out, not me. I don't have the heart to do it. But that's me.
Understood.
That's me. I'm getting the sense you're not going to be that great for the citizens of the Commonwealth that are in housing complexes.
I appreciate your perspective. However, as a judge, I think, and obviously in your position as
Judges
counsel,
have a lot of discretion.
That is true in areas that they have discretion for. But I'm also being evaluated in my ability to apply the law and to apply the law equally, impartially.
You don't apply the law, in my view. You interpret the law as a judge, right?
To an extent, there is precedent.
You interpret it. Every day, judges in this Commonwealth make decisions. A lot of them are appealed. Why do we have appeals court in SJC? If judges just followed the law, we wouldn't need the appeals court, would we?
Right, but the appeals court, as you know, as an attorney yourself, creates precedent.
So, why does a judge care if he says, hey, I'm not going to be the son of a bee that throws him on the street? It may be against the law, but I'm not following it. I like to see judges that do that.
Context also matters. I've had also plenty of cases exactly as you described, sir, where we are either having smokers, longtime smokers, 20, 30 years, or individuals who are smoking marijuana. And often why those cases are being brought forward before the court is not necessarily for the fact that they are in possession or even smoking, but because of the health effects that are happening to the other residents.
Well, that's a different issue.
But that's not, I can appreciate that, but just to give a sense of it, that is the cases that we're actually seeing in the housing court. You're seeing folks who are like, I have asthma, I have kids with asthma, I'm on an air tank. Those are what you're seeing actually coming in, not in the sense of what you're doing.
My question was not that. I'll make it even easier. It's gummies, that medical marijuana gummies that she takes. No smoke.
I do appreciate and understand your question.
Well, I hope you don't throw anybody out of a housing project because of that. I really hope you don't do that.
I appreciate that.
I'll let you go. I have received a lot of calls on your behalf. You must have a PR campaign going. You should have ran for public office, I think. Lauren Forbes, Dorchester, Alex Milvey from Jamaica Plain, Anita Sanchez from Randolph, Margie Griffin from Rosendale, Ellen Dean, D-E-H-M from Southeastern, and Ann Mackin from Hyde Park all called me on your behalf. I also got one from Joey Michalakis, yes, all on your behalf. And they all said wonderful things about you. But I didn't ask them about the marijuana issue, so I don't know how to come down on that.
I guess, sir, one of the things that I would say is that if you just look at the fact that there is both support, both the landlord side and from the tenant side.
Look, you're getting paid $190,000 from the taxpayers of the Commonwealth. Treat them good.
Yes.
Okay?
That is for sure.
Most of them aren't ever going to make that kind of money in their lifetime.
As well as council.
As well as council.
Yes, sir.
So
meaning treat them, everyone, treat them both good.
Treat the citizens good.
Especially.
Don't throw them out in the street for some foolishness like that. Stand up. Be bold about it.
I appreciate that.
Thank you.
Thank you, Council Schulenberg. Council Kennedy, do you have any questions?
I have a few comments. First of all, I had a long talk with him on the phone. Quite a bit. He answered most of my questions. I've got to point out a couple of things. First of all, I received a lot of phone calls. Number, probably no less than 30 emails. 8 or 10 phone calls from people like John Gentile, Steve Coleman, head of the CIO, who I have a lot of respect for. All in support. I did not receive a single negative comment about your qualifications. I do want to say that you know, in terms of the issue of trial experience, the housing court's a different animal. You would agree with me, right?
Yes.
Than say where I appear, which is primarily Superior District Court, where somebody's coming up from one of those trial experiences. It's crucial. Housing court, it's a lot of legal issues that get banged out, and a lot of mediation type things that go on. Is that fair to say?
Yes.
So you would agree with me that there just aren't a lot of trials in the housing court?
Yes.
Fair to say?
Yes.
The vast majority of cases are either resolved or handled by way of motion practice?
Yes, sir, or the trial would be a foregone conclusion. In the sense that if you have a tenant who owes.
Yeah, somebody owes rent, it's not in dispute.
Right.
But tenant agrees they owe the money, landlord agrees they owe the money, they just don't have it.
Precisely.
Right. So the issue just becomes a question of possession and judgment, right?
Yes.
The issue with respect to the foreclosure was a little troubling. He said that the landlord is getting the same kind of relief that the tenant is. By the way, I think we have to have a moratorium. Just otherwise, because at the end of the day, the landlord has to pay that money back. And we all know that when tenants don't pay the rent, even though there's a judgment against them, very little, right? So it's just not collected. The reason is they don't have any usually, right?
Correct.
So the landlord is out the money and somehow has to come up with 2, 3, 4, 5, 6 months rent to catch up in their mortgage.
Right.
And those large corporate banks and mortgage companies, they're not going to care that, you know, they didn't get their rent, you know, when they all of a sudden they have to come up with. We're talking about a lot of money. I mean, yeah, probably average rents here are $1,500, $2,000 at least. That's probably the low end these days. Fair to say?
Yes.
And so if you're talking about 6 months, you're talking about anywhere from $10,000 to $20,000 that they'll be behind, right? You know, a lot of money for a lot of people to come up with.
Great.
You know, it's a difficult situation, and I think the solution is probably going to not necessarily be in the courts. It's going to have to be somehow the legislature's going to have to figure something out. It's relief for everything.
Yes, sir, I would agree. And saying again, the moratorium is not in itself a solution. That's why I hope the dialogue continues to be able to provide relief.
Yes, sir. Because of COVID, nobody wants to make people put people at risk of dying because of COVID.
Right.
I don't know. So for my take, you're going to have to deal with that. You're going to get when moratorium's over, I think it was in October.
Yes, I think it's 17.
So you're gonna have an onslaught of cases, you know, it's just gonna be something the housing board has never seen. Are you gonna be prepared to handle 10 times the volume that you're handling now?
Yes, I am prepared to hit the ground running. But the other part of that is I'm also prepared, hopefully, to provide assistance and expertise to the housing court specialist who first off have that opportunity to meet with the litigants and help to resolve resolutions on some of these cases. So I hope is to be able to work with them to.
I know you call them housing court specialists, they're basically meeting.
Yes,
That's
correct.
This is that one. And try to work out an agreement with the judge. Right?
Yes.
Are we gonna have enough of those? Do we have enough resources for the tsunami that's about?
I'm sure if you were asking the Chief Justice, they'd say no.
What would you say?
I probably would agree.
Anyway, as I said, I think that we have a great deal of experience. I don't think most nominees that come before us would have a lot of primarily experience. So, but given the background, demeanor, you handled yourself extremely well today. It's a pretty tough question. Showing that you can handle it. Someone's going to use it. And as I said, an overwhelming amount of support on both sides. So I'll be going.
Thank you, sir.
Thank you, Counselor. Counselor Ianella.
Thank you very much. Questions, be more than happy to vote for the nominee when his name comes before the council next week. Thank you.
Thank you, Counselor Ianella. Counselor Judge Hurley.
Is that a promotion?
Yes. A recessive one.
Sir, I just have a question for you. You're on the housing court as an associate justice, and a landlord comes in to evict a tenant who hasn't paid rent in 6 months due to the pandemic. And that person, it turns out, was making more money with the unemployment and the $600 a week than they were making before the pandemic. And the tenant is asked, why didn't you pay your rent? And his response is, I paid other bills with it because I didn't have a moratorium on those bills. What would you do? Would you evict them for non-payment of rent?
Thank you for the question. It's not an uncommon set of circumstances, even outside of the pandemic. I think that there has. Yes, hello. Are you able to hear me, Councilor Hurley?
Yes, I am.
Okay. The hypothetical that you provided is actually not uncommon, even outside of the circumstances of the pandemic. I have seen and heard of many similar type of cases. Those are the types of cases, Counselor, that you try to bring resources to bear, provided that the homeowner or the property manager is willing to work with the tenant. You do have access, and I would very much be looking first towards whether or not the parties had actually had sat down with a mediator, discussed all the options, because you do have the RAF program. The governor has poured extensive money into providing rental assistance for tenants, and so looking at is that available? Can we access the rental assistance? Would the housing provider be willing to accept the rental assistance in order to make up the lost rent? And again, with the goal of trying to both preserve housing while at the same time preserve the housing for the tenants, and at the same time trying to assist the housing provider in not having a financial loss. So as a judge, those are the types of issues that I would be asking about. Was there an opportunity to discuss the matter with a mediator? Have they considered the financial resources that has been brought to bear by the state? What other issues might be involved in order to try to, again, preserve the housing, but at the same time address the concerns that the housing provider might have.
Okay. Father had a discretion. Either fish or cut bait. Would you evict that tenant if there were no options of it?
If there were no other defenses that would otherwise,
Yes
just to be clear,
or
if
no?
there's,
Yes or no?
yes, I would be required to have to evict. Under those circumstances, if they have no defense to possession, if the owner does not wish to continue the tenancy, then the law requires me to have to follow it and to engage in an eviction. Although, again, I would, again, prior to that decision, make best efforts to try to see if we can resolve the matter.
But if it can't be resolved,
To follow the law, and I would have to evict.
okay. Thank you. That's all the questions.
Are you finished, Counselor?
Yes.
Thank you very much. Counselor Joe Fiera.
Hi, can you hear me okay?
Yes, we can, Counselor. Thank you.
Thank you. First of all, I want to congratulate you on getting our first webinar witness. I thought that was great.
Thank you.
So, sir, I have just one quick question for you regarding the pandemic situation. I deal with real estate often. I have some properties, and there seems to be some confusion or some conflict about whether or not registries are allowing people to file foreclosure documents at this time. I understand Plymouth and some other counties do not allow anyone to file any foreclosure documents. They do not take them at the registry of deeds. Are you familiar with that?
I am not familiar with that, primarily because Massachusetts does not have a judicial foreclosure.
Okay, but if I bid out a foreclosure in January and I put down my $5,000 deposit, and the bank or myself prolonged it so that we're going to close this week, we would then have to go to the registry of deeds with all the documents, including all the proper foreclosure notices and things of that notice, so that I can properly take title, right?
Within the scope of the work that I do, Counselor, what I would say is that even if you were permitted to file the paperwork and continue forward, if the former owner was not did not relinquish possession, then in that set of circumstance, you might have a problem because the former owner may actually have, there may be protections that the former owner can exercise provided to them under the moratorium, and or the court may not permit a summary process action to be filed.
Yeah, it's very clear to me that the court won't allow a summary process action. The question is whether or not I become a lawful owner. If that's, I just wanted your opinion on that, because the registry of deeds have conflicting opinions on that, and I wanted to get your sense of what you think is the law.
I'm afraid I really could not answer that question because there are a number of details in that has come up over the past years. I'm sure you've probably followed the law in terms of, the names are escaping me, but ensuring that you have proper sort of chain of custody in terms of the right to actually be able to foreclose. So all those issues come to bear. Again, the issue before me in the housing court would be: do you actually have lawful ownership over the property in which to have standing to evict a tenant? And barring any problems that may arise under the current case law, with being able to establish that you did have that right to proceed under the contract and under our jurisdictions with the foreclosure, then then the question becomes really, the ownership then becomes moot. Just as it's more a matter of, can you effectuate an eviction under the current circumstances?
Okay.
Okay,
So
so I can tell you
that
that
my cell phone was blowing up by small property owners who don't think they'll ever going to be able to collect rent from their tenants, although they technically, you know, have to pay all the rent, and they will someday. I agree with, I think what Councilor Kennedy alluded to is that landlords, we have to pay all the back mortgages and interest and tax, because otherwise we lose our house in foreclosure, right? But the tenants, what do you think the probability is of landlords getting the rent that's accruing for 6 months, 8 months?
Did you hear the question?
Yes, I heard the question. And first, I'd like to just point out that I do understand and acknowledge the concern. I think it is going to be difficult. I think it is going to be challenging for owners and housing providers to accumulate that rent. I think in large part because of the fact that, again, you know, resources that are being provided by the state, while they have provided great rental assistance, there's only so much money in the pot, if you will. And if the economic circumstances haven't changed, then again, I mean, if there's no money coming in, then as Councilor Jurilla had pointed out earlier, how are you going to collect on a judgment if somebody doesn't have money?
Right. Yeah, I'm not sure what the answer is, but I just wanted to get your feeling on that based on your experience and in the housing court. What percent of landlords actually are going to be able to collect all the rent that's accruing and due? You know, maybe it's 2 months from now or 6 months from now.
Do you have another question, Counselor?
No, I was waiting to hear the answer about what percentage of rent I think would be collectible.
Again, I think it's going to be very difficult. I think that it's going to be a low percentage of folks that is going to be able to be collected, just given our current economic circumstances.
In the last question, have you had any experience recently? I know that the housing court put a lot of emergency kind of motions to have people evicted for health and safety during the pandemic. Have you had any experience with that?
Not since the moratorium has been put into place, sir.
Okay, no, I understand how emergency motions of that sort. All right, I thank you for your answers, and I look forward to further reviewing all your documents and things you submitted. Thank you.
Thank you, Councilor.
Thank you, Counselor. I believe I am the last, and I won't belabor this. I think this has been a very, very rigorous hearing. Maybe a little bit more challenging than one may have expected. But I have to say, in the context of the pandemic, you are in nomination for perhaps the most difficult job in the state at the time, and that is to be a judge in the housing court. I'm a realtor. I deal with rentals all the time. Well, more than most realtors do. Realtors are furious about the extension of, you know, the moratorium on payment because landlords are losing houses. And it's a conundrum. And it's almost a King Solomon's situation or a Sophie's Choice where these are going to be very challenging and difficult things. And who knows, you know, what one will decide when and if they are given that opportunity. I can say, and this is really almost an aside, what I think this has illustrated more than anything, and I see this not just as a person, but frankly as a realtor in what is happening in the market right now, and Councilor Devaney alluded to it at the very beginning, is the discrepancy in those who have and those who don't in this country is so pronounced that it is not anywhere more apparent, I think, than in housing, and who can buy and who can't buy and who can rent and who can't even rent. To be really honest, there is not enough rental out there. It is a very, very difficult conundrum that we're in, and it will only get worse. And so I applaud you for even wanting to step into this court and apply for this job. Although this is very rigorous today and maybe not what one would expect, you never know what to expect when you come to the council, and necessarily maybe you shouldn't. I mean, this is a job interview for a lifetime appointment until you're 70. You were very, very highly regarded and well thought of on both sides of these issues in the housing court, frankly, in all the courts that you've ever been in. And I know that because these are probably the only courts that I'm in on any type of regularity. So, so thank you for applying. I applaud you for it. We need more people like you. I hope after this experience, you still want to go forward. And with that, I'm going to end this hearing. Here's my gavel. Hearing is over. Thank you.
Counselor Duff. Hello?
Oh, yes.
Yeah, I just forgot to say that Steve Tolman called me, president of the AFL-CIO, and asked me to, told me all about you, so he's in your corner.
Thank you, Councilor.
Thank you, Council.
Okay, thank you so much. Great. Take a little break to our next hearing. Thank you, attorney.